Thank you, Paul, and thank you all for joining us. Mental health in the workplace is a subject that is top of mind for everyone these days, regardless of your role as an employee, as a supervisor, as a human resource professional, as in-house counsel. We have a robust agenda today. We're going to cover some statistics about mental health and the ADA. We're going to talk about the basics of mental health claims under the ADA. And then we'll cover some common challenges, identifying a mental health disability, determining accommodation, and dealing with disruptive behavior at work. We're also going to talk about the FMLA rules as applied to mental health conditions, and we'll wrap up with a reminder on some mental health resources that employers are using to support their employees. Tyler?
Thanks, Julianne. So when we're talking about mental health, let's start with square one. What are we discussing? When we're referencing mental health conditions or disabilities, we're discussing a wide range of disorders that constitute all sorts of things which may affect an individual's mood, thinking, or behavior. This includes conditions like depression, post-traumatic stress disorder, bipolar disorder, obsessive compulsive disorder, and even anxiety. And why is this important to employers? Well, as identified on this slide, the prevalence of mental health conditions within the United States is not only vast, but it's growing. According to statistical evidence, nearly 20% of U.S. adults currently suffer from some sort of mental health condition. Of those individuals, 5% of the individuals in the U.S. adult population are currently experiencing a serious mental health illness. And this isn't just limited to the adult population. Approximately 17% of individuals aged 6 to 17 are currently facing or dealing with some sort of mental health condition. So this is prevalent throughout the workforce. And with prevalence in the workforce, obviously comes additional challenges for employers. This includes increased risk, increased need for accommodation, and also increased risk to litigation and other sorts of exposure. This is reflected within charge data from the EEOC. In 2021, 37% of EEOC charges included a disability claim. Of those, approximately 1/3 included a claim of disability based on a mental health condition. That is nearly a 50% increase in the last decade from 2011 to 2021. Notable subcategories where we've seen increases are claims related to anxiety disorder and claims associated with post-traumatic stress disorder. So why is this? Why are employers now experiencing more mental health accommodation requests and dealing with more employees who are experiencing mental health conditions in the workplace than really ever before? It's a combination of multiple factors. One, there's a lack of mental health resources currently right now in the country. Either individuals are strapped for cash and lack the funds or insurance coverage to receive appropriate treatment, or treatment simply not provided. Upwards of 119 million Americans live in mental health shortage areas where there's roughly one mental health provider per 350 individuals. Around 23% of adults experiencing frequent mental health distress report an inability to afford treatment options. This has been exacerbated since COVID. Individuals have experienced anxiety and stress related to potential direct health risks related to COVID-19, such as infection or potentially infecting loved ones. Isolation through quarantine and social restrictions has led to increased mental health conditions in the population. And finally, economic and professional uncertainty, whether it's through fears of a recession or simply being interrupted professionally and isolated from coworkers. All these things have kind of created a perfect storm, so to speak, for an increase in mental health conditions within the workplace.
Thank you, Tyler. So we have a poll question here today, and the question is, how many of you have seen an increase in the number of requests for accommodations for mental health conditions since March of 2020. So we'll give you a few seconds to work on that. Obviously, there's a relevant starting point there with the onset of the pandemic. And in addition to all those factors that Tyler noted a moment ago, it does seem like just in the general public discourse that there's a bigger understanding, a bigger public consciousness of mental health, even just in the past few years. As Tyler said, there's approximately 1 in 5, approximately 20% of Americans dealing with a mental health condition. After declining for a few years, the suicide rate went up in 2021. So those are, as Julianne said, things that are top of mind for everyone. And here in the results, then those are borne out in the results. Over 55% of you, so a clear majority, say that you have seen an increase in the number of requests for accommodations for mental health conditions just in the past approximately 2.5 years since the onset of the pandemic. So we're going to talk a little bit about the ADA basics, non-discrimination, and reasonable accommodations. I'm sure a lot of you are familiar with the basics, but it's always good to have a refresher. A disability under the ADA and typically under its state and local comparator laws is a physical or mental impairment that substantially limits one or more major life activities. Now, some of you may be familiar with when we talk about the ADA, we're actually talking about the ADA Amendments Act that was passed in 2008, which significantly expanded coverage. Congress looked at a number of the rulings that the Supreme Court had made on the ADA, namely the Toyota case, and found that it was applying an inappropriately high standard for what constitutes a disability. So when we say a major life activity, a physical or mental condition that limits a major life activity, that includes a major bodily function. Disability is also having a record or a history of such an impairment or being regarded as having such an impairment. So as relevant to the issue of mental health, major life activities include concentrating, thinking, communicating, working, and a major bodily function includes the neurological system. So all that sort of adds up to that it's very difficult to come up with a physical or mental impairment, a condition that does not impact one of our life activities or one of our bodily functions. And EEOC guidance has given some semi-per se coverage to certain mental health conditions, namely major depressive disorder, PTSD, bipolar disorder, OCD, schizophrenia, and certain personality disorders. EEOC guidance says that those are conditions that, quote, should easily qualify, and many others will qualify as well. But like any disability, it's not enough to simply have the condition that impacts your life activities or your bodily functions. To be covered, an individual must be qualified for the job, meaning able to perform the essential functions of the job with or without a reasonable accommodation. As an example, a client recently came to me to inquire about an individual that was dealing with grief and was snapping at their coworkers and being fairly aggressive and rude to some of their coworkers. And the question posed to me is whether this person would be covered due to their emotional distress. And the basic answer to that is that, one, obviously that's something that we want to be very sensitive to, but simply experiencing emotions, experiencing emotional distress in a colloquial sense is not necessarily going to be a covered disability. And that puts aside the question of whether we can give a reasonable accommodation for dealing with your coworkers in that way. So this sort of covers the basics of the non-discrimination part of the ADA, the things that you're not allowed to do. We all understand that you can't take employment action against someone based upon having a disability, having a record of disability, or regarding someone as having a disability. But the ADA and its state and local similar laws are somewhat unique in the employment space in that they also place positive obligations on employers beyond simply the negative obligations of not discriminating. And that comes in the space of reasonable accommodations. In addition to not discriminating, employers have to take reasonable accommodations for individuals with disabilities. In order to qualify, an accommodation has to be reasonable. It cannot pose an undue hardship or create a direct threat to workplace safety, and ultimately it has to enable the individual to perform the job. EEOC guidance about mental health specifically has said that there can be some certain accommodations that may qualify, such as altered break or work schedules, quiet office spaces or devices that create a quiet environment, or changes in supervisory methods, such as getting written instructions from a supervisor who doesn't normally provide them, specific shift assignments, or permission to work from home. On the undue hardship and the direct threat, those are standards that EEOC is going to look somewhat strictly at. An undue hardship, EEOC is going to consider the cost, the impact on the work environment, and the employer's resources. So what may be an undue hardship for one employer may not be an undue hardship for a much larger multinational corporation, for example. And direct threat is an issue that we don't litigate or we don't deal with as much, but that's going to be looked at fairly strictly by EEOC as well, and it has to be something that's going to pose a significant risk of substantial harm to the employee or to others in the workspace. So basically, if you're thinking about undue hardship, if you're thinking about direct threat, understand that those are things that are going to be looked at pretty strictly by EEOC.
So let's look at some real-world examples of how employers can identify when a mental health condition rises to the level of a disability under the ADA. For example, depression alone may or may not constitute a disability under the ADA. As Tim mentioned, what is the critical factual analysis that takes place here is whether or not that impairment substantially limits one or more major life activities. Now, this is a fact-dependent analysis that's going to vary based upon case by case and individual by individual. The symptoms alone of a condition, for example, symptoms of depression, may qualify as a disability. These symptoms could include things like anxiety, panic attacks, migraines, or stomach problems. A real-world example of this is the case of Husch versus Delta Medical Cannabis Company. This was out of the Eastern District of Arkansas in this year, 2022. In Husch was a security guard. She was assigned typical duties as a security guard, patrolling, making sure doors were locked, making sure the facilities was secured. She was assigned additional duties on top of those tasks, which involved clerical work and more administrative tasks. Husch told her employer that these additional tasks were causing her a great deal of stress, causing her to experience depression. She was having anxiety and panic attacks as a result of these increased job duties and requested accommodation through a restriction of those tasks. Ultimately, the court, through a motion to dismiss, found that yes, these are valid potential disabilities that an employer must analyze in order to determine whether or not an appropriate or reasonable accommodation exists. Additionally, intermittent and situational mental health conditions can constitute a disability. For example, in Ramirez versus the Oklahoma Board of Regents for the Regional University System of Oklahoma, which was a 2021 case, Ramirez experienced situational anxiety, which she attributed to a hostile work environment. In other words, her anxiety would come and go based upon hostilities that she was experiencing in the workplace, and she requested accommodation related to that. The court recognized that these situational circumstances and situational anxiety and conditions can constitute a disability under the law. So that too is something that employers need to be aware of when an individual comes to them and identifies a potential condition that could necessitate an accommodation. Julianne?
Thanks, Tyler. As Tim suggested, almost everything is on the table in terms of an accommodation. In the post-pandemic workplace, especially in the context of mental health conditions, we are seeing requests for accommodation that go far beyond adjustments to the workspace. Employees are seeking reassignment, work from home, flexible schedules, and new supervisors. Let's take a look at a few examples of requests for accommodation and how the courts dealt with them. In the first case there on the screen, the Herman case, the plaintiff was a court clerk working for the city of Salt Lake. She had post-traumatic stress disorder resulting from a decades-long abusive marriage, and her symptoms manifested during hearings on domestic violence. Attending court hearings, of course, was an essential function of her job. She took FMLA for flare-ups, but after exhausting her FMLA leave and numerous conversations with her supervisor and HR regarding possible accommodations, she brought in a note from her doctor stating that the doctor recommended the plaintiff be given the opportunity to work in a different department with different supervisors. Her employer determined that because there was no accommodation that would enable her to do her current job, she was not qualified within the meaning of the ADA, and her employment was terminated. The trial court granted summary judgment for the employer, but the 10th Circuit Court of Appeals disagreed, finding that the employee's request for reassignment to a different position was plausibly reasonable, and that once the plaintiff made the request for reassignment as an accommodation, the burden shifted to the employer to engage in a good faith interactive dialogue to see whether reassignment would be a reasonable accommodation. Kind of a surprising outcome in that case. In the next cases, the courts took different views. In the Lamb case, the plaintiff was a litigation supervisor working in a law firm, and her job required her to work on a full-time basis and, when needed, work on weekends and evenings. At some point during her employment, she was diagnosed with generalized anxiety disorder and panic attacks. In response to criticism regarding her sporadic attendance, the employee brought in a note from her counselor stating that she should only work half days when she experienced intense anxiety. The employer in this case, importantly, had a written job description that included the essential functions of full-time 40 hours of work per week, personal meetings with attorneys and other staff, and in-office meetings with clients to perform certain specified tasks. Her employer, upon getting the counselor's note, concluded that the requested accommodation was unreasonable and terminated the plaintiff's employment. And the court agreed, stating that deference should be given to an employer's description of the job and its essential functions, and that the requested accommodation was not reasonable because it would not have allowed the plaintiff to do the essential functions of her job. In this case, the court also found that the parties had engaged in an interactive dialogue, and that dialogue had not resulted in identifying any additional alternative accommodations. Similarly, in the last case listed, the Brown case, the plaintiff had post-traumatic stress disorder and anxiety resulting from his military service, and he told his supervisor that his conditions affected his ability to manage stress, concentrate, and communicate. In this case, the plaintiff was a member of a 4-person team responsible for investigating fraudulent healthcare claims, so his job necessarily required him to work during regular business hours and to have in-person, in-office interactions. He sought accommodations of more work-from-home days and the ability to work on weekends to make up for his lost time in the office during the week. The employer denied these 2 requested accommodations, but the employer did agree to minimize his travel and provided him with noise-canceling headphones to wear when he was in the office to minimize distractions. The plaintiff quit his job, alleging constructive discharge and failure to accommodate. When considering his claims, the court rejected them, finding that his telework and weekend work requests were not reasonable because they would not allow him to perform the essential functions of his job, and that the evidence offered by the employer showed that the plaintiff could do his job with the accommodations that the employer did agree to provide him. These cases continue to show the fact-specific nature of this analysis and the importance of engaging in a good faith dialogue to explore possible accommodations.
Thank you, Julianne. And I'm going to talk about a few other fact-specific situations dealing with the issue of disruptive behavior. This is something that I alluded to earlier in my comments, and it's an interesting issue that we deal with in the context of mental health-related accommodations. This is probably the only type of condition that's going to result have the potential to result in disruptive behavior. And employers have to know how to deal with that. And these two cases that I'll be highlighting here on this slide show the context and the fact-specific nature of how those situations may come out. In the Trahan case out of the First Circuit in the Northeast in 2020, the employee was a call center employee, also a veteran with post-traumatic stress disorder. She was in training, and her job required close collaboration with a team of other employees. And she was dealing with PTSD, and the flare-ups or flashbacks that she would experience were sometimes the result of when she felt like she was being ganged up on by her coworkers or being criticized. And that would result in outbursts directed at her coworkers. She got into several disrespectful altercations and ultimately requested to move away from her teammates to a private office or to be allowed to work from home. Now, it's interesting, as we sit here in 2022, and we're talking about the work from home not being a reasonable accommodation. In this case, it's important to note that the court looked at that and found that the relevant facts were stemming from 2017, when the employer here would not have had any feasible way to permit work from home. It'll be interesting to think about how work from home as an accommodation for mental health or for other conditions will come out when the relevant facts are, in the post-pandemic timeframe. As a result of finding that they were not able to allow to be the close collaboration type job to allow you to be removed from your team or to work from home entirely, that would not enable the employee to do the job. Therefore, that is not a reasonable accommodation. The employer won this case on appeal. Consider the next case, how it comes out a little bit differently and how the context is important. In the CASA case, the employee was dealing with bipolar and intermittent explosive disorder. Now, the latter of which is recognized in the DSM-5 as involving recurrent behavioral outbursts representing a failure to control aggressive impulses. So obviously that has the ability to result in some disruptive behavior. The employee had previously requested and been granted by the former manager to have short breaks, to be permitted short breaks to relax and deal with the symptoms. A new manager came in and decided that that was not a reasonable accommodation and terminated the plaintiff's employment after an outburst on the phone with a client. The court ultimately reversed summary judgment. Summary judgment was granted to the employer, but it was ultimately reversed on appeal. Noting facts indicated that the plaintiff had been capable of controlling his outbursts when he was permitted to take breaks. So that will show you how the context of what has been done previously by the employer may weigh heavily in this analysis. For example, it's going to be very difficult to say that something presents a hardship or that something presents a direct threat if it's been apparently successfully given by a previous manager.
If navigating the waters of ADA compliance by employers wasn't difficult enough, you also have to analyze and assess the potential interplay of the Family Medical Leave Act. In late May of 2022, the DOL issued new guidance regarding FMLA rules as they pertain to mental health conditions. And while I describe this as new guidance, what it really is it's kind of a reaffirmation or an affirmation of what we've already kind of known regarding the FMLA and mental health conditions. One, the new guidance doesn't change anything related to eligibility or FMLA criteria. You're still going to have the same 12 months of service, 1,250 hours of service, same requirement for 50 employees within a 75-mile radius. So all those standards remain the same. Really, what has occurred within this new guidance is that the DOL has really clarified or hit on what constitutes a serious health condition within the context of mental health conditions. Next slide. And so what is that? A mental health condition is considered a serious health condition within the meaning of the FMLA if, one, it requires inpatient care, a condition that requires an overnight stay in a hospital or alternative care facility such as a rehabilitation facility constitutes a serious health condition which can warrant protection under the FMLA and require an employer to provide leave. Additionally, a serious health condition also can constitute continuing treatment by a healthcare provider, specifically a condition that incapacitates an individual for more than 3 consecutive days and requires ongoing medical treatment or a single appointment or follow-up care. If the condition's chronic, causes periods where the individual is incapacitated or requires treatment at least twice a year, it also can constitute a serious health condition. For example, that could be a situation where an individual is attending ongoing counseling sessions related to depression or some other mental health condition. Providing that individual with leave in order to get treatment is also something that can be protected under the FMLA. So if the ADA wasn't difficult enough, you also have the challenge of dealing with the FMLA context with employees.
Thank you, Tyler. And as you all probably know, FMLA leave may be for the employee's own serious mental health condition, to care for a family member with a serious mental health condition, and to care for an adult child with a serious mental health condition, provided that the child cannot care for him or herself due to the condition. So this presents, the subjective nature of mental health conditions presents some problems for employers in assessing the reasonableness and assessing the impact. And it becomes even more difficult when it may be 1 or 2 steps removed from the employee themselves. Many of you have probably seen situations with the use of intermittent FMLA, where an employee is effectively able to use intermittent FMLA with no real drawing down of that balance based upon how much they use. So we have a few examples here. Karen is occasionally unable to work due to severe anxiety. She sees a doctor monthly for her symptoms, and she uses FMLA to take time off when she is unable to work unexpectedly due to her condition. So again, this is an example both of the intermittent FMLA usage and the fact that these types of conditions may have unpredictable or purely subjective flare-ups. And that presents just the risk of abuse and also more difficulties for the employer in assessing them. Another example is Wyatt uses 1 day of FMLA each month to travel to an inpatient facility and attend an aftercare meeting for his 15-year-old son, who has completed a 60-day inpatient drug rehab program. FMLA presents a situation where we're effectively having to accommodate something that is not the employee's own condition. And finally, Anastasia uses FMLA leave to care for her 24-year-old daughter, who was recently released from a facility for mental health condition and is unable to work or go to school and needs help with cooking, cleaning, shopping, and other daily activities. This is another example of providing an accommodation effectively due to the FMLA for a family member's condition. Julianne's going to talk a little bit about some of the resources.
Sure, Tim. So recognizing the importance of mental health, employers have implemented a wide range of strategies to support their employees. Those resources could be wellness newsletters, strategies for managing stress, mindfulness training, employee assistance programs, training on mental health issues for supervisors, how to identify when employees are in need of help or perhaps in crisis, and various perks related to mental health, well-being apps, flexible leave options, and they run the gamut. And while publicizing these resources is certainly advisable, an employer should take care that when dealing with individual employee concerns, you don't jump to the conclusion that an employee is in need of some kind of treatment for a mental health condition, because doing so may be construed as regarding the employee as having a disability. That concludes our presentation, and now we're going to send you over to St. Louis, where Associates Jackie Kaufman and Blake Armstrong will provide an update on Kansas and Missouri law.